Continuity Act of 17, Second 40 of 2022.
Yes, I wanted to see the discussion of the rent receipts and the judgment of the court.
The Exhibit 9 has not been discussed at all by either of the courts.
Exhibit 9 is the
Order of the High Court. The writ petition was filed by us because the state abruptly stopped collecting rent from us. It is in that context that the finding was returned that I am in continuous possession.
where is that order?
Order, yes.
And rent receipts?
Exhibit 6.
Exhibit 6.
Exhibit 6 is the receipts.
And where is the discussion of Exhibit 6?
I'll just show you. These are the documents. We also want to see from the
Exhibit 9.
Exhibit 9 is also the page 33.
It's a compilation of the exhibits.
This is recital of your case.
Uh,
From the recital of plaintiff's case.
Then the
And Jamabandi, basically the court said that Jamabandi cannot be discontinued.
So continuous possession. That's the
From
finding
the
of the
recital of the petitioner's
yes,
case.
it is the finding of the court that it is from my case. This is borne out. So that I am in continuous possession. But this
No
has
private party to this.
no private party because the state abruptly stopped collecting rent.
Fair enough. Now, where is the discussion of Exhibit 6 in this
Kindly
case?
come to page 33. The findings of issue number 4 and 5 start at page 32 at the bottom, and then page 33 your option will find the reference to exhibit 6 to 6 by age.
33.
Right in the middle your option will find 6 percent. Where the stamp is there, stamp,
Yes.
and exhibit 4 it starts.
Exhibit 4 and rent receipt in
Receipt,
series
receipt,
exhibit. Yes.
which has been objected in a specific manner by both contesting defendants with the assertion that any surrender for a land which belongs to ST and or land or royalty land cannot be surrendered without compliance with mandatory provisions envisaged under section 72 of the CET Act. They have also objected the case of the plaintiff on the ground that Vishram Oraon did not die issueless. He has a son named Bandhan Oraon who had two sons, Jagtu and Bahadur Oraon. Jagtu Oraon had a son, Bandhana Oraon, who died leaving behind his only son, Bahadur Oraon, that is different number 1, who inherited and succeeded the suit properties from his father. And there is no such surrender has ever been made by any of his predecessor interest to the ex-landlord. Therefore, no right, title, or interest had ever perfected or accrued to the ex-landlord. Hence, he is not entitled to make any settlement in favor
So
of
basically everything revolved upon section 72.
surrender.
And this rent receipt was pursuant to surrender.
Yes, it's pursuant to surrender after a Sada Hukumnama is executed, and thereafter we have given the rent receipts till the filing of the suit.
The original tenant, he surrendered.
Original tenant surrender.
Surrendered.
That's my case.
That's it. Followed by subsequent settlements.
Sada Hukumnama followed by rent receipt.
Rent receipt.
That is my case.
And the defendants are the
Heirs of the recorded tenant.
recorded
So
tenant.
they are saying that there is no surrender. I continue to be the recorded tenant.
That surrender becomes void by virtue of section 72. That would be that must have been their case.
Yes, that is their case, and that is the finding.
That is the finding also.
I have an answer to it. It is that whether a surrender allegedly made by the landlord in contravention of 72 can be declared void. Yes, if it is a void, there is a principle that does not require declaration. But till what time? If you allow it to stand for 50-60 years, then in view of C2SAW principle also, I cannot be ousted. There is a limit to it. There is a period of limitation. Now I have been getting this rent receipt issued. There is a registered sale deed in my favor also. They have never questioned that. So it is not a fact that they don't know that I am in possession. So this issue had to be decided merely by writing one line that 72 there is non-compliance, and therefore after 50 years you say that settlement is bad. I think that would be without
The
jurisdiction.
point of limitation was framed.
It is a question of law which has to be framed by the court, and there is no discussion on that. I just see that. I just confirm it. Maintainable. But section 3 is the duty, because but this was not, in fact, this issue arose that whether the surrender is good or bad.
You claimed adverse possession as well as title.
I said if I have otherwise, in the alternative I set up which is permissible in this light of Supreme Court judgment.
Possession has been found against.
They have said that now there is nothing on record to show possession. That's
Yes.
that finding I showed of the first appellate court minutes. But that is again contrary to the record. Even if the High Court's order is not considered, the rent receipts are sufficient proof of possession. But if not anything, mutation is a proof of possession, if not of title.
So, what is your substantial question?
Yes. Kindly come to minutes D.
Essay number 40 or 20. Heard the learned counsel appearing on behalf of the argument. The learned counsel for the argument has submitted that the learned courts have not properly considered, not at all considered Exhibit 9, which was an order passed by this court in writ petition on the in which the plaintiffs claimed continuous possession of the suit property and also the rent receipt, which showed that they were in possession of the property. The learned counsel submits that rent receipt may not be a document of title, but certainly it has a bearing on the possession. He submits that the learned courts have recorded that the plaintiff has not been able to prove his possession of the property.
Yes.
The learned counsel has also submitted that the plaintiff claimed title through Sada Hukumnama issued in the year 1954 within bracket Exhibit 5, followed by issuance of rent receipt, and the Sada Hukumnama was preceded by surrender by the recorded tenant. He submits that the learned courts have recorded that the surrender was against the provision of law and therefore void. But at the same time, the plea of adverse possession was required to be considered. A specific plea was raised, but on account of the findings in connection with possession, the plea of adverse possession was also not properly admitted. Considering the aforesaid submissions and having gone through the impugned judgments, this second appeal is admitted for final hearing on the following substantial question of law. D. D and
D and I think there is another which I have not argued, but G, which is Patna High Court judgment.
वो आप adverse possession वाला बना. I do not.
D is adverse possession.
D is adverse possession. Kasat nahi kaha.
Article.
Issue notice to the respondent number.
Respondent number is I just gave it. State is there. State officer.
Issue notice to the respondent number 1 and 2 for which requisite under ordinary process and registered cover be filed within a period of 1 week. The memo of appeal along with its enclosure be served in the office of learned advocate general. Appoint a state council to represent respondent number 3 for them. That should be sufficient.
Trial court records will be summoned.
Let the records be called for from the consult court. ये इनको दीजिए. Let this order be communicated. Please.
Can I take back the compilation?
हाँ, sure. That's your problem. हाँ, इसका डेट बताइए. 27 मार्च.
27.
Password case item 9, 2nd April 62 of 2017.
Yes, appellant.
May I please? This second appeal is against the concurrent finding of two courts by the defendants.
Yes.
So, plaintiff respondents brought a suit for declaration that we, the defendants, contesting defendants, are not concerned, not related with the recorded tenants. This was the relief sought by the plaintiffs,
Are not related to.
the recorded tenants. Exactly
Recorded tenant of which property?
of the suit property,
Suit property.
of the suit.
Who was the recorded tenant?
Now, and this was also sought that they are the reversional, means one of the recorded tenant died issueless, so they are the near agnates. So the property is reverted, so they are the reversional and they are the entitled for the suit.
Who is the recorded tenant?
Recorded tenant, there are several recorded tenants, neighbors given. Just I will come directly to the appellates. Their only short case is that the defendant is the descendant of one term we use as kat betwa, illegitimate son. That is their own case, that the defendant is cut illegitimate son of the recorded tenant. Now, interestingly, record of right with respect to the suit property was recorded in the name of Budhni Orain.
She is the recorded tenant.
She is the recorded. Now, interestingly, that is also their pleading. The owner was Balo Rao and Budhni was recorded tenant, was owner for a limited purpose because they are the scheduled tribe. So female, as per the earlier ratio of the now the law has been changed. Suit was filed in the year 2008. So that is this pleading was made that I will show from the record that even the female have very limited interest. So, being the Katvetava, we have no right of it.
Katvetwa of the recorded tenant and husband of Budhni Orain.
Now that is now their case is Katvetava. Now they also developed that Bolo Rao had two wives. Bolo Ura had two wives. One was Budni, in whose name record of right was recorded, and second was Pandu. नाम थोड़ा भूल जाते हैं. पांडो उराई. तो पांडो उराई का पहले से रिलेशनशिप था किसी के साथ, तो उन्हीं का ही बेटा है इसका ये लोग डिसेंडेंट्स. So, in view of their own pleading, the plaintiff admits the respondent as illegitimate son of recorded actual owner Bolo. So, my lord, even if I am illegitimate, and it is their own case that Budni, after death of Bolo, name of Budni has been recorded. I am not coming to the further. First point is, even if it is assumed for the sake of the argument that the defendants were illegitimate son, his entitlement to inherit the property cannot be excluded. Cannot be excluded. Because earlier it was a law that female have a very limited right, and law has been discussed.
But he is not the illegitimate son of Budni Orai.
पांडो तो एडमिटेड केस है कि
Pando is another person, na?
नहीं, पांडो ओराइन वाइफ
Wife of Gola.
बोला
See,
तो बालो, हम जो भी केस बोल रहे हैं उनका
Gola
अदर सेक्टर.
Orai had two wives.
हाँ,
One
बालो
was Budni
actual.
Orai and otherwise Pando Orai.
So their case
So
plaintiff.
he could be a son of the illegitimate son of Budni Orai.
हाँ, नहीं, ये क्या हुआ इनका जो केस है, हम एग्जैक्ट आते हैं. परहैप्स आई वाज नॉट क्लियर. बोलो उराव एक पर्सन है, इनका केस हम बता रहे हैं. उनकी दो वाइफ, एक है बुधनी और एक है पांडो. तो हम लोग जो है वो पांडो से, इनका केस
Defendant.
प्लेंटिफ, हम लोग डिफेंडेंट.
अच्छा, ठीक.
हम अभी प्लेंटिफ के केस की बात.
ठीक.
और इनका केस है कि जो डिफेंडेंट्स हैं वो इलेजिटिमेट सन है बोलो उराव के. जो स्पेसिफिक प्लीडिंग है इनका प्लेंट में, और जो कि अपीलेट कोर्ट अपील मेरा डिसमिस किया, वो भी वो पैरा 2 में लिखे हैं कि प्लेंटिफ का ही एडमिटेड केस है कि द डिफेंडेंट्स आर कठबेटवा ऑफ बोलो उराव.
Illegitimate son of Golo.
कठबेटवा टर्म has been used.
And when Golo Rao died, it got record.
In
Was
the
it
name
was
of
it ever
Budni.
recorded in the name of Golo Rao?
That is their case. Ki owner was Bolo. He was earlier record of right was prepared. Thereafter, it has been recorded in the name of in subsequent, because record of right has been also been exhibited from them, and we have also produced some document, because when new record
अभी
of
तक हम क्वेश्चन ऑफ लॉ तक नहीं पहुंच पाए.
हम क्वेश्चन ऑफ लॉ को अभी ले भी नहीं जा पाएंगे, क्योंकि दोनों कोर्ट से हरे हुए हैं. तो वी आई हैव ए वेरी लिमिटेड स्कोप. सो जस्ट दैट्स व्हाई आई एम आर्गुइंग as plaintiff's case, because plaintiff has won the case in all.
See, when there is concurrent findings, we will go by the findings.
Yes,
Or you will say that it is perverse because of non-consideration of something.
yes. Oh,
Is it your case that it is perverse?
Yes, my case is
Which perverse on account of what you say?
by virtue of
By virtue of any documentary evidence or by virtue of any oral evidence?
by virtue of a documentary evidence, as well as by virtue of the subsequent law which has been changed. At the time of 2008, this was the case, but I am relying upon the judgment wherein it has been held that their case is not recorded. Female has limited right, that has been excluded. So my first submission is that is their own case that I am the illegitimate son. So I am the descendant of the illegitimate son. Now, even if I am illegitimate son, now they had to prove that illegitimate son had no right of inheritance by cogent evidence. They have to prove. Now they have to prove custom. They have stated in the plate that they cannot inherit, but they have to prove this custom by cogent evidence, and in order to prove custom, the only documents available in the record of right is village notes.
Village?
विलेज नोट बनता है जिसमें लिखाता है कि क्या कस्टम. नाउ नो एविडेंस टू प्रूव कस्टम हैज बीन एड्यूस्ड बाय द प्लेंटिफ इन ऑर्डर टू प्रूव दैट इलेजिटिमेट सन इज excluded from inheritance. So my first submission is
No evidence from plaintiff.
yes, to prove custom excluding the defendants being illegitimate son from inheritance, because that is their own admission कि I am the illegitimate son of the actual owner, Balo owner.
Was this custom disputed?
Sorry, ma'am.
Was it disputed?
Yes, yes. Because our case is just little bit different. We appeared and we said that no, we are sons of Bolo. We admitted Bolo had two wives.
See, you did not admit that you are the illegitimate.
Yes.
Did you also say that even if it is assumed that you are the illegitimate son, you have all right of inheritance? Was that your case?
No, that was not case. I was raising substantial question of law. What my lord was query was, that was the substantial question of law, that even if it is assumed, I was not arguing our case. I was arguing on my weakness. On my weakness. Both the courts have held that you are illegitimate son, so you are not entitled for it. So I am arguing on that point that both the court have misconstrued the customary law of inheritance, and in particularly when plaintiff has to prove. Now my lord, kindly see. I will show two evidence. Internal page number 8.
Of?
Learned First Appellate Court's judgment.
Yes.
Now two documents was adduced by way of additional evidence, Exhibit D and D, E. These documents and F. These were produced. Now my lord, kindly come to second paragraph, Exhibit F. My lord, got Exhibit F is the copy of the genealogy of Setley of Khata number 304 as obtained through right of information act. ये इंफॉर्मेशन एक्ट के तहत सेटलमेंट ऑफिस से genealogy recorded tenant का we have adduced. Now in this, my lord, my name is there, and I have shown that genealogy was the main question. Now the respondent said that it is beyond pleading, and now kindly see, my lord, findings. Finding starts, my lord, page number.
You read एक line मत पढ़िए, इसको पूरा पढ़िए.
हाँ.
It is submitted by the learned counsel for the respondents that this evidence is beyond pleading.
Yes, and not to be read with.
आगे पढ़िए.
In another alternate, it is submitted that defendants were residing in the village as son of Dijora. Even if they are descendants of Katwetwa, they will be recognized as the family members. It is to be mentioned that Exhibit D and E have been brought on record by way of additional evidence at the stage of appeal. Now kindly come to the finding. What perversity has been given? This documentary, this proof of genealogy has not at all been considered. Kindly see, my lord. Paragraph 15. 14 से admitted fact है, वहाँ से पढ़ लेते हैं, ज़्यादा it will be better. The following facts are either admitted or proved. Bolo Ura was having 2 wives. The defendants claim their right title in interest being descendants of Bolo Ura through the relationship of Pando Urai. It is the case of the plaintiff that after death of Budhini Urai and also after the death of Mahavir Rao and Biro Rao, who died issueless, they are lenient descendants of recorded tenant. It is also proved or admitted that the name of Budhini Urai was recorded in the record of right and the name of Pando Rao or Dhijo Urai was never recorded in the record of right. Dear Automated findings. I have considered the argument. My Lord will say from, if my Lord will permit, I will read entire. Otherwise, my Lord may look into the findings only 2 paragraphs and the important documentary evidence in relation to genealogy.
नहीं, आप 15 पढ़िए.
My Lord, I have considered the argument of the learned counsel for the respondents that even a widow woman have a limited right of interest and the recording of the name of Budhni Orain only and not Pando Orain proves that Pando Orain had not come with any male descendant bond with the relationship of Bolo Orain and further that predecessor in interest of defendant that the Dhiju Orain was not connected any way with the recorded tenant. It is also proved that Bolo Orain was not alive at the time of preparation of record of right. I have considered another aspect of the case. In this suit, title suit such and such was brought by the plaintiff respondent for a relief that it be declared that property of schedule B of the plaintiff belonging to the plaintiff since the right title of the predecessor in interest being the last reversioner, last male descendant against the defendant number 1 to 5. Needless to say, defendant is not before being for declaration of his right, title and interest and the defendant's appellants have not come before the court after payment of the court fee regarding his declaration of his right, title and interest even by way of counterclaim. The plaintiff have not come of a declaration before the court that defendants are Katvetwa of the recorded tenant of Bolora. In fact, it was a circumstance placed by the plaintiff for placing its case that they are the last lineal male descendants of the recorded tenant. The appellant defendant have not come why this finding has been before the court for declaration of his status as a son of Bolora. Any documentary evidence could not be produced by the appellant defendant for showing that the Pando Rai had not come before the Bolora with a son from his earlier husband. I have earlier stated by virtue of section 102 of Indian Evidence Act, the initial onus was the plaintiff for proving a prima facie case and it discharges that onus and makes out a case which entitles to him a relief. The onus shifts to the defendant to prove those circumstances which would disentitle the plaintiff to the same. I wish to reiterate that virtue of Exhibit 1, the plaintiff respondent had amply proved that there was none else than Budhni Orai whose name could have been recorded in the record of right. Exhibit 2 is the admitted document. Exhibit 3 is the admitted document of defendant appellate in which the SDM clearly observed that the appellants are the Katvetwa of Bolora. I find that even after this finding of the SDM, the defendant did not come before the court either for declaration of his right, title, interest or for rectification in the record of right. Per contra, the defendants have admitted that Bolo Ram was having 2 wives, but the name of mother of Dhijo Ram, that is Pando Rai, has never been mentioned anywhere. Appellant defendant did not make any objection either under section 83, 84 and section 90 of CAT Act.
So Pando Orain was the second wife.
Second way. Now we file a documentary evidence. ये जो देख रहे हैं धीजो ओराव का, ये धीजो ओराव का उस एग्जिबिट में मंगाया गया सेटलमेंट ऑफिसर के यहाँ से राइट टू इंफॉर्मेशन एक्ट में जो हम लोग लाए. These evidence exhibit D, E and entirely discarded. So this finding is perverse on account of non-consideration of those material documentary evidence. हम लाए भी है फाइल, हम ये वो लाए भी हैं इसीलिए मंगवा लिए थे इसको. इसमें ये देखिए आपको माय लॉर्ड विल फाइंड दैट नेम ऑफ Dhijo Rao is there.
Or the learned counsel appearing on behalf of the appellant. The learned counsel for the appellant has submitted that though the appellate court has recorded that additional evidence by way of Exhibit D, E, and F were brought on record at the appellate stage in order to substantiate the genealogy and the status of Bijo Ram in the family. But by recording finding in connection with point of determination कहाँ है?
नॉन कंसिडरेशन में बना दिया जाएगा.
But by recording finding, those exhibits have not been transferred. The learned counsel for the appellant has submitted that the genealogy had a bearing in the matter as the plaintiff was claiming that the recorded tenant had died issueless
died issueless, and the defendants are illegitimate, cut betwa,
and the defendant were descendants of Kat Vitwa, that is illegitimate child of recorded tenant, namely Bola Ora. He submits that the improved judgment passed by the learned appellate court is perverse, and therefore this appeal be admitted by framing a substantial question. Considering the aforesaid submissions, this appeal is admitted on following substantial question of law: whether the findings recorded by the learned appellate court is perverse on account of non-consideration of the additional evidence led by the appellant before appellate court by bringing on record exhibit D, E, and F. That's all. Let notice be issued
May I break?
to the respondents for which requisite under ordinary process as well as registered cover be filed within a period of
1 week.
1 week. Let the records be called for from the concerned court. Let this order be communicated through fax to the concerned court.
Customary law of inheritance भी बना देते तो ठीक है, क्योंकि law, my lord is well aware, law is very dynamic. After the judgment of the 2023, my lord is well aware that
What's the 23?
illegitimate inheritance, whether the findings of the learned court appeal is vitiated on account of misconstruing customary law of inheritance.
23 का कौन सा judgment?
ये जस्टिस डी वाई चंद्रचूड़ का जजमेंट है जिसमें रेफरेंस हुआ था, कन्फ्लिक्टिंग डिसीजन था इलेजिटिमेट सन के बारे में कि इफ एनी सन इज बॉर्न आउट ऑफ वाइड मैरिज ऑल्दो इट वाज अ मैटर ऑफ हिंदू सक्सेशन एक्ट, in that case reference has been decided in that paper. That's why मैं आई एम
customary law पे नहीं बना।
अच्छा ओपन कर दीजिए कम से कम
Open तो हमेशा ही
डीपली
company is required to receive.
डीपली
Date 27 March.
माइल
Item 18, second to 190 of 2022.
May it please your lordship. This is, my lord, the plaintiff's second appeal against the judgment of appellant. Suit was filed, my lord, for declaration of title and confirmation of possession in the alternative lordship for recovery of possession with respect to Schedule B lands, and my lord for declaration that the sale deed dated 6/6/1992 executed in favor of the defendant is a forged and fabricated document.
Who executed it? Who executed the sale?
Executed by one Gopal Napi.
Who was the recorded tenant?
Now lordship may kindly see, one Jagannath Napit Milord was the recorded tenant with respect to the lands Milord measuring an area of 64 decimals appertaining to plot number 259 of Khata number 20. Now lordship, Jagannath Napit sold the lands 11 decimals of land to Baidnath Mandal in the year 1971. Again, my lord, the recorded tenant Jagannath Napit sold 9 decimals of land to one R.C. Sharma in the year 1971. Then lordship, Jagannath Napit sold lordship 9 decimals of land to Gunadhar Ghosh in the year 1973. And lordship, son of Jagannath Napit also sold 13 decimals of land to Gunadhar Ghosh on 13th of December 1975.
Yes.
And lordship, Gunadhar Ghosh sold lordship 9 decimals of land to the mother of the plaintiff, namely Saraswati Devi, by virtue of registered sale deed dated 10/11/1982.
10, 11
1982.
out of this 13 decimal.
Lordship,
1982.
13 and 9 out of 22 decimal.
No.
Gunadhar purchased.
Gunadhar is son of Jagannath.
No. Jagannath sold
Achha,
9
Gunadhar
decimals of
sold
land.
9 decimal.
Guna-
And son of
Jagannath lordship, Gopal Napit, son of Jagannath, sold lordship 13 decimals of land to Gunadhar on 13th of December 1975. Now lordship, Gunadhar sold 9 decimals of land to the mother of the plaintiff by virtue of registered sale deed dated 10/11/1980. Now lordship, mother of the plaintiff came into exclusive possession over her purchased lands, and she got, my lord, her name mutated in the revenue records and rent receipts were duly issued in her name.
for 9 decimal or 9 plus 13?
9 decimals.
For 9.
9 decimals. Mother of the plaintiff, my lord, has purchased 9 decimals. Now lordship may kindly see. The defendant, my lord, has not disputed the sale deed executed in favor of the plaintiff.
That is 10,
The-
11, 1982 is not in dispute.
Not. The defendant has stated, my lord, that we have no manner of concern with the suit land. Now lordship may kindly see the findings of the trial. Rather, my lord, the defendant has admitted the sale deed executed in favor of the plaintiff by Gunadhar Ghosh. He is disputing, my lord, the area sold to the plaintiff. Without challenging, my lord, the sale deed executed in favor of the plaintiff. How can it be? One sale deed has been executed and the defendant has admitted the sale deed. How, my lord, the area of sale deed can be challenged in the suit by the defendant
Boundary is
without
challenged or area is challenged?
area is challenged. So area it can only be challenged by filing cross suit. Now Lordship may kindly see the findings of the learned trial court. Issue number 7 and 8, Lordship, has been dealt with by the learned trial court, my Lord. Finding, Lordship may kindly see para 25, internal page 20. Para 25, Lordship, of trial court judge. Now I find that it is the case of the defendant that Gunadhar Ghosh never sold and could not have sold an area of 9 decimal to the plaintiff mother, possession of only 6.5 decimals of land in plot number 259, Khata number 20, village Balrampur, which he acquired by purchase in 1973, and the plaintiff mother never purchased an area of 9 decimal on the basis of LS sale deed. Now, Lordship, this is important.
This plaintiff's mother purchased from whom? She purchased from Gunadhar Ghosh.
Gunadhar Ghosh?
Gunadhar Ghosh had only 9 decimals.
No, Lordship. Gunadhar Ghosh purchased 9 decimals and 13 decimals. It is an admitted case. Now, Lordship may kindly see. I further find that the defendants have not challenged the sale deed number 4080 dated 10/11/1982, but the area mentioned is challenged that when Gangadhar Ghosh never sold and could not sold an area of 0.09 decimal. How can it be, Lordship? The sale deed executed in favor of the plaintiff has never been challenged by the defendant. Now he is challenging the area which has been mentioned in the sale deed. I have been able to prove, Lordship, that the mother of the plaintiff has acquired the suit property by virtue of registered sale deed in the year 1982, and her name was duly mutated. Rent receipts were duly issued, and this fact has been admitted by the defendant.
Likhiye heard the learned counsel for the appellant. The learned counsel for the appellant submits that the fact that mother of plaintiff acquired 9 decimal of land by virtue of registered sale deed dated 10/11/1982, executed by Gunadhar Ghosh, stood admitted by the defendants.
Lordship.
But in spite of that, the area covered under the sale deed was disputed
Lordship, this is the case.
while passing the impugned judgments.
Lordship.
The learned counsel has referred to the substantial question of law number 2 as framed in the memo of appeal. Considering the submissions, this second appeal will be heard, is admitted for hearing on the substantial question number 2. Issue notice to the respondents for which requisite be filed within a period of 1 week under registered cover as well as honorary process. Let the records be called for from the concerned court. Post this case on 27th of March.
Oblige.
वही एक नंबर 2 जो है
Lordship. Oblige.
For hearing, item 19, second appeal 382 of 2018.
Praying for an settlement in this matter.
refused.
The last date notices were issued on
They are not active, that's their problem. You don't bother about
Question of law has been framed. It has to be argued. That's my senior question. The assistant.
it. No, we are not going to do it.
It may be posted tomorrow as the first case.
Where is a substantial question?
Order number 6 dated 9/2/2020.
Order number 6. Read it.
Only seeking that it be posted a short pass over.
I will record in my order that the council has refused to read even the substantial question of law. Should I? Yes, read it, please.
This appeal will be heard on the following substantial questions of law. Whether the learned first appellate court has committed perversity by ignoring the fact that the vendors of the plaintiff, having no title as she has no document except a Sada Hukumnama, which is not admissible in evidence, the sale deed executed by her in favor of plaintiffs could not have conferred any title upon the plaintiffs. Second is whether the learned first appellate court committed gross illegality in holding that the plaintiffs have proved their right title, interest, and possession over suit land by ignoring the fact that the Deputy Commissioner Dhanbad in case number 11 of 82 by order dated 31/12/83 has annulled the thoka containing the suit land, and the land has been acquired by state government and given to defendant number 45 appellant by case number 11 of 2 83/84, and delivery of possession of the suit land has been given by government of Bihar to BCCL wide exhibit.
Question number 1 I understand. What is the import of question number 2?
This matter was
जो चेंबर में नहीं फाइल करते उनको कोर्ट में पढ़ना पड़ता है. कोई बात नहीं, घर में टाइम नहीं मिला होगा, पढ़िए. इम्प्यून ऑर्डर पढ़िए और इस क्वेश्चन ऑफ लॉ को फिर से पढ़िए. रीड इट वंस अगेन. आपके सीनियर आपको फाइल ही देते पढ़ने के लिए, तो नहीं क्यों नहीं पढ़ते?
actually the land was acquired by state government.
Let us read it.
Yes. So
You do not know. Let us
this
read.
was acquired by cancelling the Jamabandi of the appellants. Of
Acquired
the
means acquisition under which provision?
acquisition.
Land acquisition act.
Land acquisition.
The property here was acquired by the state government. Correct? आप ये पढ़िए. ट्रायल कोर्ट का जजमेंट पढ़िए. ज़्यादा लंबा नहीं पढ़िए. शुरू करिए.
Let me show this is a reversal. So the trial court judgment.
पहले
was
ट्रायल
not-
कोर्ट जजमेंट. Read the trial court judgment. Just plain English,
Yes.
but
From the first point.
yes, from first.
The plaintiffs have brought this suit for a decree.
एकदम fast reading.
For a decree declaring plaintiff's title to the land fully mentioned in Schedule A of the plaintiff, confirmation of their possession, and decree for permanent injunction, restraining the defendants number 1 to 3 and their men, agents, representatives, and servants. 1 to 3 would be us mentioned. Representative servants from cancelling the mutation of plaintiff's name drawn up in Jamabandi number 150 and 151 regarding Schedule A land of the plaintiff, and from handing over possession thereof to BCCL. The case of the plaintiff in short is that lands under Khata number 45 of Moja Intanali stood recorded as Gair Abad Malik. In the last survey of survey records of right, we say the land is Gair Abad, and the said Khata number 45 consists of several plots. One Srimati Devrani Devi, she is the vendor from whom the plaintiffs have derived title, allegedly derived title. Wife of Sri Bhuvaneshwar Singh Chaudhary took settlement of 3 acres of land out of total area of 3.70 acres. In plot number 125, Khata 45, White Hukumnama dated 8 Ashwin 1353 BS, granted by the landlords, and said Srimati Devrani Devi was in possession of the same since then by exercising diverse acts of ownership and possession, and her name was mutated in the Sharista of state of Bihar and she had been acknowledged as Rayat for the said 3 acres of land taken settlement of Tulka Jamavani number 79 of the village has been drawn up in the name of Srimati Devrani Devi, and rents have been realized from her by Anchal Office Bagmara from the vesting of estate of intermediaries in the state of Bihar, and up to date rent receipts have been issued in her name. While in peaceful and undisturbed possession over this said land, Srimati Devrani Devi sold and transferred this said 3 acres of land to the plaintiffs. Wide register sale deed number 12734 and 12735 dated 24/11 to 82 for valuable consideration, and plaintiffs being put in possession of their purchased land since the date of purchase have been exercising diverse acts of ownership and possession. The names of plaintiffs have been duly notated in the register of state of Bihar by mutation case number 80X of 8283 and 91X of 8283, respectively of Bagmara Anchal, and updated rents have been realized from the plaintiffs by Jamamuni number 150 of the village. Thus, the plaintiff have been recognized as Rayats for the said land by the state of Bihar through Bagmara Anchal office, and updated rent receipt have been issued to the plaintiffs. Further case of the plaintiff is that on the basis of notice dated 3683 from the office of Anchal Adhikari, Bagmara, the plaintiffs went to Anchal office on 9683, showed the papers regarding their title with respect to land fully mentioned in Schedule A of the plaint. Then Anchal Adhikari also directed the plaintiff to show the papers of Schedule A land to AC Dhanbad. Plaintiff showed the papers to Additional Collector Dhanbad camp at Bagmara Anchal office on 4786. Anchal Adhikari told the mutation entries in the name of plaintiff were going to be cancelled. Land in question were going to be handed over to BCCL. Does the plaintiff know that the Jamabundi drawn up in name and with respect to Schedule A land is going to be cancelled by defendant 123 on frivolous plea that the said lands are vested in the state of Bihar and possession of the suit land is going to be handed over to BCCL? The plaintiff produced all documents before the defendant number 123, but no avail. Plaintiffs sent a notice under section 80 dated 11/8/86 issued and served upon defendants through counsel, but defendant did neither reply to the said notice nor have till late informed anything to the counsel. However, plaintiff have come to know that matter is still pending at AC level, as informed from officials of Anchal on 21/2/90 when the plaintiff number 2 went to pay rent for the said lands. Further, plaintiff submit that and state that no doubt plot number 125 under Khata number 45 was recorded as Gairabad Malik land during the last survey settlement operations. It is further case of plaintiff that before vesting of Zamindari in the state of Bihar, the then landlords, including the ex-landlord of Moja Bhim Kanali, had full and absolute right to make Raiti settlement of Gairabad lands, and once such settlement was made under law, the survey record nature of the land changed from Gairabad to Rayati. This very right the state of Bihar inherited from the ex-landlords after vesting of Zamindari. It is further case of plaintiff that Rayati lands, as aforesaid land of the other type, did not vest in government state of Bihar with the vesting of Zamindari under operations of PLR Act. Further case of the plaintiff is that the aforesaid action of defendant 123 in so modo attempting to cancel the Jamabundi drawn up in the names of plaintiffs is unjustified, malified, motivated, and if transformed into action, it will put the plaintiffs to irreparable loss. The cause of actions of the present suit arose on 10/7/86, 11/8/86, 21/2/90, and subsequently thereafter it is still continuing from day to day within jurisdiction of this court.
Yes, read it. Continue.
In the instant suit, the plaint after filing was admitted and notices were issued against the defendants. In instant suit, all defendants appeared and respectively filed their written statements. Defendant 1, 2, 3 appeared in suit, filed their WS as per their WS of the case. Defendant, the case of the defendant 1 to 3 is that land in question is recorded as Gairabad during cadastral survey, and after vesting of Zamindari, said land vested in the state of Bihar. It's further stated that said Sada Hukumnama has got no value in the eye of law, and even today, for Sada Hukumnama, backdated Hukumnama is prepared and issued to grab the valuable government land, and Sada Hukumnama does not create title over government land. The further case is that opening of Jamabandi and granting of rent receipt does not create title, and as such the plaintiff have got no right title interest over the government land. Defendant number 4 to 5, that is the appellants, also appeared in the suit and filed their WS stating therein that the suit lands were never in past cultivating possession of Devrani Devi, and so-called Hukumnama is a false document. Further case is that in mutation case of Bagmara Anchal in the name of Devrani Devi in respect of suit land along with other lands are collusive, fabricated or manufactured. So issue of rent receipt was collusive, forged and fabricated documents, and BCCL has obtained the said lands on payment to the state of Bihar when BCCL had applied before district administration for acquisition of 224.46 acres of land in Khata number 45, which gave rise to case number 11 of issue of 83-84, and for the time being, the district administration Dhanbad 42.5 acres of land in Khata number 45 is transferred to BCCL on 26/11/87, including the land mentioned in Schedule A of the plaintiff. And BCCL has been in peaceful possession over the land, and the DC Dhanbad has already annulled TOCA containing the plaint mentioned in Schedule A of the plaint in case number 11 of 82/83 by order dated 31/12/83, and in view of the matter, the entire case of the plaintiff is falsified. Plaintiffs have no case at all.
Did you produce any rent receipt by the ex-landlord?
Leadership, I received the property through
Might have.
acquisition.
Is there any rent receipt from ex-landlord?
The rent receipt has to be proved by the plaintiff, by the respondent.
You are the
I am the appellant, defendant number 4,
defendant number 4. Who is defendant number 4?
BCCL.
BCC. Okay. So, this hukumnama, let us see the case of the plaintiff. Based on hukumnama, not coupled with any rent receipt issued by the zamindar. Did they exhibit any rent receipt by the zamindar? Because they say that this particular land got converted into Rayati land and this hukumnama was there. This is their case.
Yes, they have exhibited rent receipt, but only after vesting of zamindari estate. That is after whenever the zamindar would have submitted his
What is
returns.
the earliest rent receipt they have produced?
1983.
There is one more rent receipt, Exhibit 2. What is the date of Exhibit 2? Original hukumnama is Exhibit 7. Mal Guzari receipt 6/6 to 6/8.
Those are also of the circle office.
We do not
Halka
know, we just
Karmachari.
want to know. Now, basically the main issue was issue number 6.
Our case is very simple. The vendors did not have a clear title. They could not have transferred it to subsequent plaintiffs, which the appellate court has declined.
So this story of hukumnama and all these things was declined, was not accepted by the tribe. What the appellate court has done? Yes, please.
Ladyship, the ground on which the appellate court has rejected my claim has been and delivered the judgment in the favor of the plaintiffs. First ground that has been rejected, that there is absolutely no finding over the hukumnama, but the court has come to the finding that I failed to say that the sale deed that was issued by Devrani Devi was forged and fabricated. My case is never that. I always say that even if the sale deed has been issued by Devrani Devi, she never had the right title and interest to issue any sale deed in favor of the plaintiff. Now, secondly, there is absolutely court is silent over the Sada Hukumnama, which is not registered one. Jamindari, second ground on which it has been decided in favor of the plaintiffs is that The defendants failed to bring on record the Jamindari returns before the court to show that Jamindari returns were never filed in the name of Devrani Devi.
Let us see the finding. Para
Yes.
11.
Yes.
Point of determination, para 10.
Yes. एंड थर्ड एक चीज़ और उन्होंने कहा कि रिकॉर्ड्स ऑफ राइट में जो चेंजेस आए हैं आफ्टर फाइलिंग ऑफ द सूट इन 2005 दैट हैज़ नॉट बीन चैलेंज्ड बाय मी आफ्टर कमिंग ऑफ दैट ऑर्डर which is a summary proceeding and that was only for to the extent of correction in the records and that has been taken note by the appellate court.
You read the point of determination and para 11.
Later. Internal page 6, running page 21, para 8.
Para. Okay, fine. Para 8.
Or shall I read from para 6, ladyship, after the issues?
No, this is the basically the discussion of the
Discussion of all
evidences.
the incidents. Para 8.
Para 8.
Heard both the sides, the learned counsel of the appellant states that the learned court below failed to appreciate that ex-landlord tenure holder intermediaries had the right to keep the land of Gair Abad Malik Khata in his khas possession. In the instant case, the outgoing tenure holder, namely Hari Prasad Singh Chaudhary, Shri Prasad Singh Chaudhary and Bhuvneshwar Singh Chaudhary, all sons of late Manilal Singh Chaudhary, settled 3 acres of land out of 3.70 acres of land under plot 125 Khata number 45 of village Bhim Kanali to Srimati Devrani Devi, wife of Bhuvneshwar Singh Chaudhary, by Hukumnama dated 8 Ashwin 1353 DS. Since then, she was in possession of the
What is the corresponding English calendar to this? Any idea?
1947 lady.
1947?
Yes.
After 1/1/1946? So this is a transfer. 1947. Okay, let's see. Let's see. Continue, please. Since then,
She was in possession of the suit land. After vesting of the state in the state of Bihar, her name was mutated in the government register and she was paying rent. The district administration Dhanbad has wrongly transferred some of the land of Gairabad Malik, including the suit land, to BCCL. The CO is not competent authority to make transfer of government land. The prescribed norms procedure were not followed by the district authority. Khata number 45 of village Bhim Kanali was in Mal Khewar of Manilal Singh Chaudhary and Mahavir Singh Chaudhary, and the same was in khas cultivation possession of then tenure holder. Devrani Devi has sold the suit land through 2 registered sale deeds in favor of plaintiff's appellant. The plaintiff's appellants were mutated and started paying rent to the government. The learned lower court has erred in appreciating the documentary evidence of record filed by the appellant's plaintiffs. Jamabandi once created cannot be cancelled. Several other Rayyat whose case were on similar footing have filed title suits which were decreed. During revisional survey operation, the suit land was wrongly recorded in the name of Bihar government, RS Khata number 76. Then the plaintiffs have filed suit number 5125 of 05 under 87 CNT Act, which was allowed on 9/1/2009. I'm just pointing out this suit was this summary proceeding was filed in the year 2005 during the pendency of these proceedings, these suits. The learned counsel of the appellant has discussed the detailed oral and documentary evidence on record and urged the court to allow the appeal by setting aside the judgment passed by the learned court, lower court in title suit number 73 of 90. The learned government
this is arising out of title suit number 73 of 90.
90.
Continue, please.
The learned government leader appearing in the state for the state and the learned counsel appearing for BCCL have stated that the learned lower court has not committed any error in deciding the suit. The suit was rightly dismissed. The said hukumnama and execution of sale deed by Devrani Devi are nothing but paper transactions to grab government land. The plaintiff appellants have not filed any copy of return to show that at the time of vesting of the state and state of Bihar, the outgoing landlords have shown Devrani Devi as tenant for the suit land. After due verification and adjudication, the then Deputy Commissioner Dhanbad has cancelled Jamabandi of the plaintiff's appellant, so the same cannot be challenged after passing of 20 years or more. The government leader and learned counsel appearing for BCCL have discussed in detail the oral and documentary evidences on record and urged the court to dismiss this appeal by upholding the judgment decree passed by the learned lower court entitled suit number 73 of 90. Peruse the records. On the basis of the above discussed facts and the arguments, in this case, there are only 2 points of the for consideration, in my opinion, to decide the appeal. Point number 1. Have the plaintiff's appellants right title interest over the suit land on the basis of the sale deed executed in their favor by Devrani Devi? Point number 2. Whether the running Jamabandi of plaintiff's appellants were cancelled by the concerned authority according to law, and is BCCL entitled to hold the suit land on the basis of transfer made to them by the state government. As both the points are for consideration are interlinked, so to avoid the discussions and appreciation of oral and documentary evidences on record, I have kept taken of both the points for consideration together for determination. For point number 1 and 2, the plaintiff's appellants claim to purchase the suit land from Devrani Devi thereafter their name were mutated in the Shirista of state. They started paying rent in lieu of their possession of the suit land in Jamabandi number 150 and 151. Later on, state government has transferred the suit land along with other lands to village Bhim Kanali to BCCL defendant number 4 and 5. Then the plaintiff have brought the suit. Shiv Kumar Rai, PW7, one of the plaintiff's appellants, has stated that on 24/11/1982 he has purchased the suit land from Devrani Devi through registered sale deed. Then after got their name mutated under Jamabandi number 150 and 151, they started paying the rent to state government in lieu of their possession. He has claimed that the plaintiff's appellants are still paying rent to the state government. Basudev Pandey, PW10, is formal witness who has proved the rent receipt. Shiv Kumar Rai, PW6, has stated that earlier Devrani Devi was paying rent to the state government in lieu of her possession of the suit land on the basis of hukumnama executed in her favor of ex-landlord. Gokul Chandra Pandey, PW8, has proved the rent receipts in Exhibit 5 series of the plaintiff and their vendor. Abhayanand Prasad, PW9, is another formal witness. He has also proved the rent receipts. Exhibit 2 series. Prahlad Chandra Pramanik, PW7, has proved certified copy of sale deed number 12734 dated 24/11/1982, Exhibit 3 through Volume 2, which he brought from Registry Office to the court as per order of the court. He has also proved sale deed number 12735 dated 24/11/1982. Shiv Kumar Rai, PW6, has further stated that he has given the original sale deed to his learned lawyer, which were misplaced. Then he has filed certified copy of the sale deeds. He received no notice from the CO office regarding cancellation of his Jamabandi. Indrajit Prasad, DW1, has deposed before the court on behalf of BCCL defendant number 4 and 5 and has stated that he was appointed as Amin in the year 1981 in BCCL. The suit land is about 3 acres of land under Khata number 45, plot number 125 of village Bhimkali, which was recorded during cadastral survey operation as Gair Abad land. On perusal of the certified copy of Khewat Exhibit 8 and 9, I find that Khewatdar of Bhimkali were Manilal Singh Chaudhary, Khewat 1 by 1, Mahavir Singh Chaudhary, Khewat 2 by 2, under Khewatdar Babul Neelkant Singh Chaudhary or Khewat number 1, Khewat number 2 by 3 was under joint Khewatdar, Khewat number 2 by 1 and 2 by 2, Khata number 45 of village Bhim Kanali, having 3 plots, that is plot number 125, area 3.70 acres, 248, area 54.04 acres, and were recorded as Jungle Jhari, whereas plot number 197, having area 28 decimal, was recorded as house and courtyard. The certified copy of the Khewat in Exhibit 9 one another plot, that is plot number 107, was recorded. Party having area 1.43 acres, obviously during cadastral survey, operation plot number 125, khata number 45 of village Beam Kanali was Jangal Jhari and Gyarabad Malik land, which finds support from the deposition of Indrajit Prasad, DW1, who has further stated that Bihar government has issued arm ishtihar on 18/5/83
You
and
come to page
invited
number 12. Internal page. In favor of Devrani Devi by Sada Hukumnama Exhibit 7, and thereafter she started paying rent to the ex-landlord. Is there any evidence to this? If there is no evidence, you have a case. And if there is evidence, you have a case. Because Sada Hukumnama unregistered has no value. But if it is followed by Zamindari rent receipt, it has a lot of value.
Devrani Devi was the wife of one of the Jamindars, under whose name the land was
That is,
recorded.
so that is not the point. If there is no legal bar, that hukumnama cannot be issued in favor of any family member, right? Hukumnama is there if hukumnama is followed by any rent receipt issued by the zamindar. I don't think that there is any exhibit to that effect. Is there any
Yes.
exhibit?
3 Malgujari receipt they have produced. That is as a concept we will point out. Exhibit 6 to 8. But the law is elections that Jamindari Sada Hukumnama followed by a Jamindari return and subsequent election creation of Jamabandi can only create a rent.
Sada hukumnama followed by zamindari rent
Zamindari
receipt,
rent
followed by zamindari return,
Return.
and then
Then recognition under elections
By the
land
state.
reform act is
under the
section
land reform.
6, 7 or 8.
Six,
Those
seven.
are not there. Only 3 Malgujari receipts and those receipts during the Jamindari regime. But that cannot be proved as any authentic document unless lordships somebody proves that yes, this is the signature of the Jamindar, because land revenue receipts as on today is used by the public.
Was that under challenge?
Actually, we were given the land by the state government on that those documents were produced. Now, Your Lordship, they say they do not produce any rent receipt subsequent to abolition of Jamindari. They do not produce any record of Jamindari return. They say Sada Hukumnama. This Honorable Court in a pattern of decisions have held, Your Lordship,
So Sada hukumnama,
has to be followed by a Jamindari return and a recognition under section 6, 7 or 8.
you see, they are the successor in interest of the property. The zamindari return, they may not be having the zamindari
It is a
return.
public document. If I have to produce the record of right, I have to obtain a certified copy and produce.
Zamindari return is not a
Not
record
a-
of right.
No. Zamindari return is the basis on the basis of which record of right after abolition of Jamandi is created. There are,
Zamindari return does not form a part of record of
no, it does not form. On that basis only the record of right is created with respect to the lordships Rayati land.
What is the earliest rent receipt they have produced? By the state?
Prior to abolition of Jamindari only, and no subsequent. No,
Subsequently?
by the state, no rent receipt has
No,
been.
rent receipt has been produced.
Only 3 Malgujari rent receipts, exhibit 6 to 6 by 8.
No. There are other rent receipts also on record. There are other rent receipts also on record.
That is in the name of Devrani Devi. Exhibit
And
2 to 2 by 8.
Devrani Devi is the vendor,
Devrani Devi
is the vendor of the plaintiff.
Yes.
So it ought to be in the name of Devrani Devi only.
Exhibit 2 is Lordship 1980, 31/3/1983 and 2C to 2D is 15 to 1997.
the rent receipts have been marked without any objection from the renter. All of them. Even the hukumnama has been marked without your objection. Where is the zamindari rent receipt? Which exhibit is zamindari rent receipt?
Exhibit 6 to Exhibit 6 is
एक भी नहीं दिख रहा. Just see, all these are rent receipts. Exhibit 2, 5 and 6 all are government rent receipts, not zamindari rent receipts. They are all government rent receipts. Government is a party. So, this zamindari rent receipt. Hukumnama is not followed by any zamindari rent receipt. So, it has got no value. Plaintiff is not appearing. Somebody has entered appearance. Who? Who is for the state? They are not bothered because the property has
They got the
now.
money from us. And
They have got the money from you.
Yes, also we requisition for the acquisition of the land. They gave the land to us and they took the money from us.
They are not realizing. Who is appearing?
Rajesh Ranjan, Chandan Tiwari, Avinav Tiwari and Rishi Ranjan Vats.
On the previous occasion when I prayed for 9 minutes, they were here and I took their consent.
हमको तो नहीं दिख रहा जमींदारी रेंट रिसीट कहीं पर. And in their memo of appeal, they are referring to government rent receipts, Exhibit 2, 5 and 6 series. And the appellate court records the finding that it was followed by zamindari rent receipt. So that is not so. हमको तो नहीं दिख रहा.
नहीं, जमींदारी हमको भी नहीं लगा. हम उसी फाइंडिंग का बेसिस में नोट्स बना लिया था.
टाइम नहीं मिलता है रिकॉर्ड देखने का.
My learned friend had seen the records. It was not there.
जहाँ हुकुमनामा देखिए पहले जमींदारी रेंट रिसीट खोलिए. That is the first thing which one has to see because it's an unregistered document. Apart from this returns not filed and एक बार जमींदारी रेंट रिसीट आ जाने के बाद बहुत मुश्किल है उसके अगेंस्ट very difficult. And most of the time all the documents are exhibited without any objection. इसमें सारे documents have been exhibited without any objection. And immediately after vesting कोई भी rent receipt हमको नहीं दिख रहा. I don't think so there is any rent receipt immediately after
Not
vesting.
immediately, the dates are. Earliest rent receipt was of 31/3/1983.
Yes. And she was claiming property on the basis of sale deed dated.
She has purchased via sale deed dated. 24/11/1982.
क्या करें?
Give them one more opportunity.
Opportunity तो हम दे ही देंगे. उनके absence में नहीं करना चाहते ना.
जी.
इससे कोई फायदा नहीं. So let's come back to the first question of law.
First question of law is whether the learned first appellate court has committed perversity in ignoring the fact that vendors of the plaintiff having no title, as she has no document except a Sadhu Hukumnama, which is not admissible in evidence. The sale deed executed by her in favor of the plaintiffs could not have conferred any title upon the plaintiff.
This is factually correct. That except hukumnama there is nothing.
Except Hukumnama, there is nothing.
There is nothing.
Legally, there is nothing.
Yes. No, except hukumnama prior to vesting.
Prior to vesting, there is
nothing.
There is
Except
nothing.
hukumnama. Let's see the second one.
Whether the learned first appellate court committed gross illegality in holding that plaintiffs have proved their right title, interest and possession over the suit land by ignoring the fact that Deputy Commissioner Dhanbad in case number 11 of 82 by order dated 31/12/1983 had annulled the thoka containing the suit land and the land has been acquired by the state government and given to the defendant number 4-5 appellant by case number such and such and delivery of possession of the suit land has been given by the government of Bihar to BCCL by exhibit B on 26/11/1987.
पोजीशन के बेसिस पे टाइटल नहीं है. एडवर्स पोजीशन का कोई क्लेम नहीं है. कुछ नहीं है. पोजीशन के बेसिस पे टाइटल नहीं है.
एक और चीज है, so suppose the land has been acquired. I have been not shown as a land lessor and it has been given to the company or the person in whose or authority in whose interest the land has been
They have
acquired.
a remedies
They have a
under
remedy under the Land Acquisition
Land
Act
Acquisition
to claim the compensation.
to claim compensation
They
for
cannot-
whatever be the status.
Yes. But once it has come to the knowledge of the court that it has been acquired and given to a third party, title could not have been declared in there.
तो बताइए जजमेंट अभी लिखा है कि क्या करना है?
So as a counsel, I feel like, but parents that it would be an embarrassment to the lawyer also if they continue. It is their ignorance and negligence.
The documents regarding acquisition were produced,
Yes, Lord.
notices etc. were produced.
Notices were produced and the document of handing over of possession by the state government has also been produced.
Acquisition was of the year
So acquisition is of the year 1987. Possession was handed over in the year 1987.
87.
And acquisition is of case number 11 bracket 2 of 1983-84.
11 bracket 2 of
1983-84.
83-84. Essay number 382 of 2018. Also for the appellant and present, आप लोग सब अपना appearance दें. Nobody appears on behalf of the respondents. In spite of valid service of notice, the respondent number 1 and 2 has appeared by filing wakalatnama, but the counsel of respondent number 1 and 2 is not present. Nobody is appearing on behalf of the state respondent number 3 to 5. 3 to 5 is state respondent.
Yes, sir.
This appeal was admitted for final hearing by the order dated 9/2/2023 on the following substantial question of law. Their various orders. The learned counsel for the appellant, while advancing his argument with respect to the first substantial question of law, has submitted that the plaintiff claimed title through the vendor, who in turn claimed title through a hukum, sada hukumnama. He has further submitted that there is no material on record in connection with any document of title except sada hukumnama prior to vesting. He has also submitted that the sada hukumnama was not even accompanied with rent receipt issued by the ex-zamindar, and therefore it did not show any delivery of possession. The learned counsel has submitted that sada hukumnama by itself does not confer any title upon the holder of the hukumnama. He has further submitted that there is no rent receipt placed on record by the plaintiff. Even immediately after vesting, rather the earliest rent receipt is of the year 1982-83. The learned counsel submits that the issuance of rent receipt by the state by itself does not confer any title. The plaintiff was basing his title on the hukumnama, and hukumnama itself did not confer any title to the predecessor in interest of the plaintiff. Therefore, the first substantial question of law is fit to be answered in favor of the appellant and against the respondent plaintiff. The learned counsel has further submitted that the property involved in this case was subject matter of land acquisition in case number 11 with bracket 2 of 1983-84. After following all the procedure, the delivery of possession was also given to the government by the government of Bihar to BCCL by Exhibit B on 26/11/1987, and the appellant has already paid the required compensation to the government. The learned counsel submits that the plaintiff, if had any title, ought to have raised objection, ought to have taken steps in the acquisition proceedings, but no such step was taken, and subsequently the suit was filed. He has further submitted that in view of the aforesaid facts and circumstances, the second substantial question of law is also fit to be answered against, in favor of the appellant and against the plaintiff. Since nobody is appearing on, we will not record your appearance like this. After, at the stage of dictation, after the aforesaid dictation of the order, the counsel, नाम बताइए किसकी तरफ से आपके कर?
For private
तो बहस करिए, फिर क्या है? आप तो आ गए, आगे। Mr. नाम बताइए अपना? Mr. Abhinay Kumar appears and he submits that he has filed wakalatnama on behalf of the private respondent and he does not have the brief. And therefore he is not in a position to assist this court. आप किसकी तरफ से? उनके साथ हैं? कब करना है बताइए? कल नहीं हो पाएगा वेडनेसडे। पर आप लोग को थोड़ा भी रिग्रेट नहीं होता बोलने में कि फाइल नहीं है? थोड़ा सा तो होना चाहिए।
The 5 was their lawsuit, but
Misplaced.
no lawsuit, not misplaced lawsuit. Some other counsel has to appear lawsuit. There are 4 persons, but lawsuit.
4
Yes,
persons have entered wakalat and all of them were absent. No accountability for your client.
That's why I'm begging for
आज allow कर देते हैं इस order, इस case में.
no lawsuit.
Fit to be allowed.
1 minute.
You have heard the हुकुमनामा के साथ कोई जमींदारी रेंट रिसीट नहीं है और टाइटल नहीं है तो बाकी सब कहानी, राइट? दिस इज द लॉन्ग एंड शॉर्ट ऑफ द स्टोरी.
What's paper 5?
कोई बात नहीं, आप आराम से पढ़िए. Post at his request, post this case for further hearing on Wednesday to be taken up at 2:15 as the first case. NCR counsel, the learned court master is directed to retain the records received from the concerned court so that the counsels may go through the same. Jen,
Lawsuit that you will be
नहीं कर सकते. You see, केस हार जीत अपनी जगह है, शोभा नहीं देता है, काउंसिल को शोभा नहीं देता, और नहीं संभाल सकते हैं तो इतने सारे जूनियर्स हैं क्यों नहीं रखते हैं? मतलब प्रॉब्लम क्या है जूनियर्स रखने में? डर है जूनियर्स से, आजकल सीनियर को डर लग गया है जूनियर लोग से. जो ज़्यादा रिसर्च कर लेता है, जो पसंद नहीं आ रहा है सीनियर. करेक्ट? आई एम टेलिंग यू, वी आर सीइंग स्टूडेंट्स लोग इतना बढ़िया रिसर्च करके देते हैं, कुछ कहने का नहीं, देख के मन खुश हो जाता है. वी हैव लॉ रिसर्चर्स, वी हैव इंटर्न्स, इतना अच्छा काम करके देते हैं कि आपको हम क्या ही बताएं. इतना बढ़िया रखिए, इंटर्न रखिए, जूनियर रखिए, सब रखिए, कोर्ट में ऐसे खाली मत रहिए.
Passover case from supplementary list item 7, contents table 784 of 2024. Along with item 8.
क्या फाइल? What is it that you are filing? What is it that you are filing?
Colored Shobhan was filed yesterday, madam, in 8:48, and we have almost madam, taken all efforts, madam, to comply your lordship order. Now the matter is only pending to be approved from the cabinet, madam, and it will take 10 to 15 days time, madam, for getting approval of the rest of the matters we have done, madam, because of your lordship's order, madam, we have done.
एक ही तो लाइन का बात है. ऑर्डर नहीं पसंद आया, सेट असाइड करा दीजिए. We
नहीं,
don't have
आप-
any egos
कंप्लाई कर रहे हैं। अगर रहता तो वो अपील में चले गए रहते।
नहीं कंप्लाई करिए नहीं
comply
करिए,
करने में
इससे हमको बस
वही
इतना
process
ही है
हाँ,
कि भाई एक लिटिगेंट आता है, केस फाइल करता है, उसका
Exactly.
ऑर्डर होता है,
exactly.
उसके बाद शोभा नहीं दे, सेट असाइड करा दीजिए, हम लोग को क्या ही मतलब।
नहीं, I
It's no
understand the
problem.
pain of the petitioners also. I have been that side also.
ठीक है, बताइए कब रख।
After 15 days or 20 days, whatever your lordship please, इसमें इस बीच में हम कंप्लाई कर देंगे। मैंने ये एफिडेविट है, पैरा 14 they have stated.
Content civil number 784 of 2024 with content civil number 848 of 2023. The learned counsel for the parties are present. The learned counsel for the state 5 has submitted that a show cause has been filed pursuant to the earlier order. The learned counsel has referred to paragraph 10, 11 and 12 of the show cause to submit that. Further 10 days time is required to comply the order. आपको 1 महीना टाइम देंगे, आप चिंता नहीं। Further 10 days time is required to comply to place the matter before the cabinet for approval. He submits that the concerned Secretary of Rural Development Department नहीं ऐसे नहीं, he submits that the matter be posted after 15 days. आपका ये submission है ना, after 15 days.
हाँ,
And he has assured that the order of this court will be complied. Post this case on 27th of April.
27 ना?
और ज़्यादा टाइम चाहिए, 27 फरवरी, आज 7 तारीख है, 6 तारीख है, 1, 2, 3 weeks हो गए, you need more time. 6th of March.
मैम,
Post this case on 6th of March in the supplementary cause list.
मैम,
The time is being granted considering the fact that the net council has assured on behalf of the aforesaid secretary that order will be done. The supplementary should first be filed by the compliance report then,
मैम,
compliance report
मैम,
be filed by 4th of March.
मैम।
कुछ पेमेंट करना है आपको, पेमेंट होना है आपको,
नहीं, नहीं,
Reasoned order has to be
रीजन ऑर्डर अब तो हो ही गया है सर।
हो ही गया, कैबिनेट से डिसीजन
अगर रिजेक्ट करना होता है तो मैडम आपके पास रीजन ऑर्डर का रिजेक्शन आता है, कैबिनेट के पास गया, इसका मतलब दैट देयर इज अ लाइक्लीहुड ऑफ सम पॉजिटिव डिसीजन।
तो हम लोग बोले हैं कि वी आर कंप्लाइंग विद
स्टेट के सूट का ध्यान दीजिए आप, ऐसे एब्सेंस मत देखिए। अभी प्रीवियस केस में
हाँ,
अगर मान लीजिए कि अगर अपील डिसमिस हो जाता, आपने तो अपील नहीं फाइल किया है, राइट, बीसीसीएल ने अपील फाइल किया है, और अगर अपील डिसमिस हो जाता है क्या कॉन्सिक्वेंस होगा?
वेरी सीरियस कॉन्सिक्वेंस। I will ask
किसी को लगाइए भाई ऐसे,
हाँ,
यू आस्क समबडी टू बी हियर, कोई तो रहना चाहिए ना स्टेट का, स्टेट का मैटर रहता है, इतना नेग्लिजेंस आप लोग का एब्सेंस भी शोभा नहीं देता।
From supplementary list for underwriting for orders item 4 contempt civil 442 of 2022.
Yes.
Pursuant to order dated 25 and 25 you mentioned, the state was directed to take instructions and file affidavit with OP number 2 I filed that so
OP number 2 has filed for
So
cause.
called, stating therein that they are awaiting the report of the Department of School Education regarding the equivalency of the degree of Fakulia and Maulvi
क्या
certificate.
हो? कौन हो? आप हो?
I'm from OP number 2, on the last, let me see the last order first. On basis of the show cause notice which was filed, on basis of the show cause which was filed by us, got the directed respondent state to file a counter. Supplementary.
Various state.
Yes, I am the city also.
क्या हुआ? ऑर्डर समझ नहीं आया?
Your
Very
Worship,
last
I am
one.
not counter affidavit तो फाइल so far फाइल नहीं हुआ.
लास्ट ऑर्डर है आपके पास?
Last order.
आपके फ्रेंड लोग आपको बहुत हेल्प करते हैं. मुझे भाई ऑर्डर की कॉपी एक निकाल के रखना चाहिए फाइल में.
जी है.
या फाइल भी नहीं?
ना फाइल है. 442.
पढ़िए पैरा नंबर 3.
The learned council of the state is directed to take instructions from the concerned authority and file an appropriate affidavit before the school.
देखता है. The reply is awaited from Department of School Education and Literacy or the Department of Personal Administrative Reforms and Rajbhasha, Government of Jharkhand. आपकी बात नहीं सुनते लगते. स्टेट वाले आपकी बात नहीं सुनते.
2 weeks time, Your Worship. Last time, Your Worship.
कॉपी भी नहीं फॉरवर्ड किया होगा. ऑर्डर की कॉपी फॉरवर्ड किए? नहीं पता. कौन है आपके सीनियर?
Suchendra Prasad, Your Worship. Suchendra Prasad.
इसीलिए आपको भेज दिया. You are for OP number 2. उनको तो नोटिस हुआ था.
So the date filed are show cause. BGMS.
लिखिए contempt case civil number 442 of 2020. The counsel for the parties are present. The learned counsel for the state pays for more time. Pays for 2 weeks time to comply to order dated 24/1/2025. Post on 28th February in the supplementary clause list. अगली बार जो है ना, अगर मान लीजिए आपको इंस्ट्रक्शन ना मिले, जिन ऑफिसर्स का नाम लिखा हुआ है ऑर्डर में, उनका नाम लेके आइएगा, उनको बाइंडिंग पार्टी बना के कंटेंट प्रोसीडिंग के अगेंस्ट ना आप भूलिएगा, ना हम आपको भूलने देंगे इस बात. ठीक है? 28. जिनके पास पेंडिंग है, दे आर ऑल्सो लायबल फॉर कंटेम्प्ट. तो लेके बैठ नहीं सकते. रिजेक्ट कर दीजिए, कोई इशू नहीं. बैठ नहीं सकते. आप ठीक से मिलते नहीं है क्या इन लोगों से? ठीक से नहीं मिल रहे आप लोग से. मुलाकात किसको बोलते हैं मालूम है ना? झारखंड में सबको मालूम है.
Item 5, First April 20 of 2025.
Limitation of
Yes.
limitation of
कितना दिन का लिमिटेशन?
42 डेज क्या होगा?
कंडोन कर दें. IA number 1141 of 2025, the council for the appellant has submitted that the petition has been filed for combination of delay of 42 days in filing this appeal. Counsel for the respondents has no serious objection to the prayer for combination of delay. Having gone through the executory application and being satisfied with the cost shown, delay in filing the appeal is condoned. IA number 1141 of 2025 25 is hereby allowed. Admit. Call for records from the concerned court. नोटिस भी जाएगा? ये तो है कि सारे प्राइवेट पार्टी आपको भी आपके में नहीं है, हाथ से बना है. Issue notice to respondent number 4 to 9 for which recusals under ordinary process as well as registered cover be filed within a period of 10 days from today. Respondent number 1 to 3 is represented by the learned counsel for the state. Accordingly, no notice be issued. Pro forma हो चाहे कोई हो, notice तो करना ही पड़ेगा.
As a matter of fact, they are plaintiff before court. They are not.
कोई बात नहीं.
They do not win.
आप उनका वकालतनामा फाइल कर दीजिए.
They do not wish to come to the court.
नोटिस तो करना ही पड़ेगा ना. कोई भी ऑर्डर होगा तो उनके ऊपर बाइंडिंग होगा ना. कैसे करेंगे बाइंडिंग? इसमें बहस का कोई मुद्दा नहीं है. पार्टी है, नोटिस जाएगा.
समय थोड़ा बढ़ा दिए थे.
10 दिन बोले ना.
थोड़ा सा
15 दिन, 15 days. ठीक है. Post on 27th March. Let this order be communicated.
From daily leave to order item 4.
और कोई डिफेक्ट नहीं ना है आपका?
नहीं सब
हम चेक नहीं किए हैं.
नहीं ऑर्डर्स में आया. ऑर्डर्स में चेक में नहीं आया.
अच्छा चलिए.
Item 4. First appeal 103 of 2016.
There are two cases. I have filed supplementary affidavit stating that department want to withdraw this case.
FA number 103 of 2016. The learned counsel for the appellant has submitted that a supplementary affidavit has been filed mentioning that the appellant wants to withdraw this case and a permission for withdrawal notice. आपको कोई objection? The learned counsel for the respondents has no objection to the prayer for withdrawal. Accordingly, this appeal is dismissed as withdrawn. नेक्स्ट केस में भी हो रही है. दोनों में फाइल किया हुआ है. आपको साइन करना होगा. आपका वकालतनामा नहीं है.
वकालतनामा इसमें ऑथराइजेशन allowed to my
अच्छा allowed on instructions of affidavit फाइल कोई मतलब ही नहीं. चलिए आप साइन कर दीजिए. शेयर कर देंगे.
Item 6 CMP 1078 of 2022.
Yes, appellant.
My lord, after a service report it came, my lord, that respondent number 21 and 28 is no more. They are dead, my lord. My lord, I want to rectify, my lord, for serial number 21, my lord. As per the decree, it was struck off, my lord, and there was a defect also in the second appeal that we have to struck it off. So again, we have been struck off in CNP, my lord. Inevitably, my lord, the notice was sent, my lord, by the advocate clerk. So far as serial number 28, we have filed IA for substitution.
Serial number 21 was already deleted.
Yes.
In the decree itself.
Decree itself. Yes. That is defect number 22 in the second appeal. I've gone to the records.
Second appeal.
Defect number 22.
CNP number 1078 of 22. The learned counsel for the appellant, the petitioner has submitted that as per office note, opposite party number 21 has expired. He submits that the CMP arises out of second appeal number 457 of 2018, and in the second appeal, the corresponding defect was that the said opposite party number 21 was deleted in the decree under appeal, and he may not be made party. He submits that in such circumstances he may be permitted to delete the name of opposite party number 21.
It has been deleted, my lord, as CMP also.
इसमें CMP में already
Yes, yes, yes. Most probably. Inevitably, the notices were sent, my lord.
Okay. The learned counsel submits that the opposite party number 21 has already been deleted in the CMP. So far as
28 minute, there is no date of death.
No, I have I have come across from service.
One has to ascertain and give the
just a
date.
moment. So far as opposite party number 28 is concerned, the learned counsel submits that he has filed interlocutory application for substitution along with the prayer for convocation of delay. He submits that the appellant came to know about the death of opposite party number 28 through only on 24/1/25. However, the date of death has not been mentioned in the interlocutory application. The learned counsel submits that if the notice is issued to the proposed legal heirs and successors, they would be in a better position to give the exact date of death. Correct? Issue notice to the proposed legal heirs and successors of the deceased respondent number 28, whose details have been mentioned in paragraph 4 of the interlocutory application under ordinary process.
Yes.
Under ordinary process, the requisites be filed within a period of 15 days from today.
Yes.
Post this case on 27th March.
One more thing, I have to substitute in the cause title, my lord. That has to come.
अभी नहीं,
अच्छा.
वो आएंगे,
Oh, yes.
उनका कोई ऑब्जेक्शन होगा,
Yes.
तो उनको सुन के करें. हो सकता है वो बोले कि अभी जिंदा है. You never know.
Oh, yes, yes.
ना, बिना उनको सुने substitution allow नहीं कर.
Then, my lord, I'll file a requisite of the CMP in the IA.
Only in the IA. Only in the IA.
IA.
ठीक है? वो लोग आ जाएंगे या CMP में भी कर. बताएं.
जो उनका राइट
कर देते हैं, दोनों को कर देते हैं.
And also in the CMP.
Yes.
ठीक है? दोनों में कर दीजिए.
Grateful.
आप क्यों परेशान है सब्स्टिट्यूशन को लेकर?
हम कोई पता
ठीक है ना?
लेकिन सेकंड अपील में वो जो डेट ऑफ डेथ नहीं रहने से हम लोग को
नहीं वो तो जरूरी है, वो बताएंगे ना.
किए हैं
इसीलिए लिख दिए हैं कि जिनका डेथ हो गया है वो लीगल हियर आएंगे, वो खुद ही बताएंगे कब डेथ हुआ है.
And the situation was such when I informed the same day, they were not in a position to know all the names. So from the locality, they have gathered the names.
और हो सकता है एक आध जुट जाए, एक
Yes,
आध डिलीट हो जाए. We
yes,
do not know.
yes, yes.
इसीलिए नोटिस जरूरी है, सिर्फ ऑर्डिनरी प्रोसेस किए हैं. नहीं आएंगे तो पुलिस स्टेशन के थ्रू भेजेंगे.
Yes.
That is कभी-कभी ज़्यादा इफेक्टिव हो जाता है सर्विस.
रजिस्टर्ड पोस्ट में इनइफेक्टिव
इनइफेक्टिव हो गया रजिस्टर्ड पोस्ट. एडी आता है नहीं आता है, हम सोच रहे बंद ही कर दे. वकील साहब का खर्चा भी लग जाता है अननेसेसरी. लिटिगेंट का